to the Saturday show, a special edition of Time Served. And yes, this is happening Thursday, April 20th at 7:30 Eastern. Credence and Mikey will be joining Time Served for a special live show. We're going to have a little of court, little cops, little Karen, little chases, whatever going on that day. Just gonna shoot the shiz, have fun, make sure you're there. Mikey will be here hanging out with us. Welcome to the Saturday edition. How you doing, everybody? As the regulars are trickling in, I have a couple clips that I've been saving and one from the other day that you are going to love. It is crazy, and we're gonna get an ending, not right now, but we have it ready to go. So this is going to be part one. Do not miss it. How we doing, everybody? So glad we're all here. Let's get to the show. Let's get rocking and rolling, people. What's up, everybody? We go. Let's get it going. How is everybody Saturday? I am ready to have some fun. We are going to start this. This is a one that I've had saved for a while. I am so glad I saved it for a special show. Here we go. Let's have some fun. Just listen to what this guy had. Yikes. Here we go.
He's still attempting to connect to audio. There he is. Okay.
Hi, Mr. Hazen. How you doing?
Oh, yeah, if you can give me
Sir, I can barely hear you. I think you've got us muted.
Okay, is this better?
That's a lot better. Thank you.
Okay. I had rotator cuff surgery Thursday, but I'm doing great. Glad to be here.
Well, we're glad you're here, and I'm sorry it's under these circumstances. Miss Bradley, are you his attorney?
Yes, Your Honor.
Are you Brent Hazen?
I am, Your Honor.
Okay, let me call this case. This is the state of Texas versus Brent Hazen in cause number 2001. Mr. Hazen, you know that you're here today because you're going to enter into a plea bargain agreement with the state?
That's correct, Your Honor.
Okay, would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth?
So help me God.
Thank you very much. You may put your hand down. Mr. Marcantel, please tell me what he's charged with.
What the offer was, Judge, that we said?
What's he charged with?
Oh, was he charged with? Okay. He is charged with count one. He was charged with possession of marijuana between 50 pounds and 2,000 pounds. And count two, he was charged with possession of controlled substance, penalty group 2, less than 1 gram tetrahydrocannabinol.
Good grief, what is that?
Fancy word for tea.
Good grief, what is that? Look at him. Mr. Rotator Cuff got a lot of weed.
THC.
Okay.
We having, marijuana.
Good grief.
Mr. Hazen, do you know what you're charged with?
I do, Your Honor.
And do you understand that today you're here to
Pounds.
plead to this case? Is there a reduction by any chance, or is
Yes, ma'am. The deal we've come up with, Your Honor, is we're dismissing count one, and then on count two, we're reducing it to a misdemeanor class A under 1244B, and we're assessing a $1,000 fine plus court costs of $294.
so he's actually pleading to a class A misdemeanor?
Yes, ma'am, on count two. And count one, again, we're dismissing.
Pounds of marijuana, that's a pretty good deal.
Correct. Very good deal.
Mr. Hazen, this is a sweet deal.
God is good, and he watched out for me. And I'm not going to participate in this again, Your Honor.
Yeah, right.
Let me ask you some questions. Do you understand that you have a right try this case if you want to.
Yes, I do.
And are you entering into this agreement because you want to or because somebody's threatened you or promised you something?
No, I want this. Yes, I'd like to get on with my life.
Okay. Miss Bradley, has the state proffered you all the discovery to which you're entitled in this case?
Christopher
Yes, Your
Douglas.
Honor.
And do you think that he has the mental capacity to enter into a plea bargain agreement?
I do, Your Honor.
Good. Mr.
With all that weed, are you kidding me? He's in mental capacity. He's high as hell.
Hazen, are you a U.S. citizen?
I am. Yes, Your Honor.
Good. We don't have to worry about your immigration status then. Well, I've been given a lot of paperwork.
Yes.
And
Yes.
you heard the prosecutor, Mr. Marcantel, explain what's going to be required of you on probation. Is that correct?
Yes, Your Honor.
And this is not a deferred, is it? Is it a regular?
It's just a regular, Your Honor.
Okay. So, sir, this is a regular probation. When you finish it,
Your Honor, it's not probation. He's just paying a fine and court costs, no probation at all.
dadgum, that's a
Yeah.
great deal, Mr. Hazen. Can
I
you pay?
support the blue. I support the blue.
Can you
I
pay?
really do.
Have you got the money to pay?
Yes, the fines imposed by the court. Yes, I do, Your Honor.
Any problem with terminating this early if he pays off? As soon as he pays, it's finished, correct?
Correct.
How much
And Your
does-
Honor, he's supposed to pay today at the time of the plea.
Are
I'm
you-
hoping he'll call the clerk's office right afterwards here and pay with a credit card or debit card or something like that. Is that what he's doing, Miss Bradley, or how are we doing this?
I'm a
That is
little,
my understanding, Mr. Marcantel.
he just got out of surgery. Mr. Hazen, are you physically able to get to them and pay today?
Yes, somebody is gonna. Well, I wanted to talk to the clerk of the court and see what they want. Sometimes, if I was to FedEx money order for the case, that could get there by the end of this week also. Or I can do look at my balance amounts and pay by credit card also. But it will be handled. I have the money.
Apparently they want it today.
Okay, I can do that, Your Honor.
Your Honor, may I ask a clarifying question of Mr. Marcantel?
Sure.
Mr. Marcantel, this can be done via phone, correct? He can pay by credit card over the phone?
Yes, ma'am.
Okay.
All right, so Mr. Hazen,
Yes, Your Honor.
to this charge you're pleading guilty or not guilty?
I'm pleading guilty, Your Honor.
Okay, and Mr. Marcantel, do you want to prove up this case, although he's already pled guilty? Go ahead and put whatever you want on the record.
Oh, yes, ma'am. Oops. My computer has frozen up on me. Hold me, go back in. Let's see.
Good grief, it's a sweet deal. Take it. Have you ever heard a judge say that? It's a sweet deal.
Okay, if this case had proceeded to trial, the state would have proven beyond a reasonable doubt that on or about the 18th day of August 2021, the
Dave.
defendant did then and there intentionally or
Judge Sargent's
knowingly
new job is
possess a
second day.
controlled substance, namely tetrahydrocannabinol, an amount of less than 1 gram. In addition to the oral summary just given, we'd also like to introduce into evidence State's Exhibit Number 1, which is the plea papers before the court, and also the 3914 signed by both parties and submitted to the court.
Any objection, Ms. Bradley?
No, Your Honor.
Okay, so it's entered into evidence without objection. Good luck, everybody.
Thank you, Your Honor.
Good luck, Mr. Hazen.
And Your
Thank you,
Honor,
Your
I'm
Honor.
not sure if
Thanks
you
for
have
being
that
here.
dismissal already before you. If not, I'll send it right now to the court
I'll tell you
coordinator.
what, before everybody goes away, I've got a ton of paperwork on this gentleman. I've got the court's notice to defendant of rights, blah, 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 blah. Range of punishment, he seems to understand that.
Baby.
Recommendations. Acknowledgement and waivers.
Thank you,
Acknowledgement
Dave.
of council.
Grab your memberships, people.
Plea agreement and consent to waiver.
Madison, I hope everything's good with the fam.
See some places where some attorneys need to sign. I do not, I see where I need to sign. I do not see a dismissal.
Okay, I'm gonna send one to Miss Hughes right now.
Does this gentleman know who to call about the money?
Happy Saturday.
It's going to
love
call
Your Honor.
Thank you.
Culbertson County Clerk.
We got a number?
Are they on the line by chance right now? Miss
Aradin.
McDonald,
Is that how
are you
say
there?
it?
Or
Aradin.
Yes, I am.
Hi, Miss McDonald. How you
can you
doing?
tell them what
Well,
to do?
I'm well, thank you.
Miss
And he
McDonald,
needs
could you please tell Mr. Hazen what your telephone number is?
432.
Write it down. Can you write it down, Mr. Hazen?
Yes, ma'am. 432.
283.
Don't talk over her. Go ahead.
And the last four digits are
Thank you, Heather, for the
2058.
memberships.
Read it back to me, Mr. Hazen.
Grab your memberships,
432,
people. It's raining
283.
memberships.
2058.
Yes.
Come on, we love this guy.
I do have a motion to dismiss Mr. Markenthal.
You do great. Thank you, Judge.
Is that correct, Ms. McDonald? Does he have the correct telephone number?
Yes, ma'am.
Okay, so they just go through the thing. All right, so next
Mr.
one.
Hazen,
Here we
Record
go.
order be adopted but modified.
My favorite, Judge Mark Bronlick from Michigan, Mr. Wendy's, Mr. Bouncy House, Mr. Chick-fil-A himself. And this is a nasty little fight. I actually renamed this file Nasty Couple. Okay, you are going to enjoy this one. Let's have some fun. Happy Saturday, everybody. Thank you for all the memberships, guys. I hope you grabbed your memberships. My moderators are telling you how to grab your free membership gifted by the lovely people in the chat. Thank you, Heather. Thank you, Dave. Here we go. I like being back in that bottom left corner. That's my home right there. Bottom left, baby. Here we go. Let's play it.
Namely that the party shall use app close for all communication regarding the minor child. Party shall use a shared calendar on app close for anything that is scheduled for the minor child. If the minor child is medically unable to attend the school in person, the minor child shall be enrolled in online or remote school. That is the recommendation. Mr. Enix, first of all, do you understand the recommendation?
I do, but I would perhaps like to have something added to that. Just that I would like to have my therapist, Dr. David Sislow, be able to have contact with who we just found out, whoever Ms. Simon's therapist is, if we could get their information to share with my therapist, so they can have a conversation that he would like to have. And basically, I feel like that would be in help in going the right direction.
Okay, I do recall the name Dr. Sisso. He is your therapist, is that correct?
Yes, sir.
Okay, I remember that from the past some time. And you're asking, do you have contact with whom, Dr.?
I'm not sure who they had mentioned it earlier. Dr. Lake is all I was able to get out of it, but that they can, my therapist can contact her office.
Okay. Dr. Lake is whose doctor? Is that your child's doctor?
I'm assuming it's Ms. Simon's.
Okay. Mr. Chappell, do you know what he's referring to? Is Dr. Lake?
I do. It's Julia Lake. She's been seeing Ms. Simon to deal with the issues that are created between Ms. Simon and Mr. Enix. We presented a statement from her today with Mr. Walker, indicating that Mr. Enix had tried to reach out to Ms. Lake multiple times to get information about Ms. Simon's sessions. And when they would not give him information because, of course, it's protected, that he became irate as well as verbally abusive to their office. I don't know. I don't know why, and Your Honor, I can show you the same statement that I showed Mr. Walker, but I'm not sure how the parties' personal therapists having contact with each other moves the ball forward.
He also has a history with Ms. Simon. Dr. Sislo does.
Okay, so
It's also been
each have
seen
your
by him as
individual
well.
therapist. Why is it important for the two therapists, your individual therapists, to talk, Mr. Enix?
Because there's a concern about enmeshments and things with the child. And in order for both therapists to have both sides, like right now, Mr. I'm not sure what her attorney's name is making
Chapel.
a claim that I contacted her attorney, but can't provide a date. I'm prepared to provide any phone records to show. I didn't even know today that she even had a therapist. I've been asking for probably over a year for that information. And he's somehow got a statement saying I called there.
Okay,
Which is a complete fabrication in this court right now.
Okay, well, let's get past that. Has Dr. Slisso recommended this or suggested this to you? That'd be helpful.
In fact, I was with him yesterday, and he made sure that I brought this up today for that to happen. He has his own concerns that he wants to voice with the. He won't tell me because he doesn't want me. He wants to talk to the other professional dealing with them to see what their professionals can come up with. And I feel like, in my opinion, that's a good thing.
Mr. Chappell, perhaps there's no harm in just allowing Dr. Lake and Dr. Sislo to communicate with each other. Maybe they may be able to share thoughts, suggestions, information on how to assist each of their respective clients and how to co-parent through the illness, the medical condition of his child.
Yeah, my client has indicated she has no issue with it. So
Okay.
it probably is better that Dr. Sislo has contact than Mr. Enix. So
right. We should leave it to the two doctors communicate, not the parties.
Yes.
So probably each would have to sign an authorization. So Mr. Enix, you'd have to contact Mr. Sislo and authorize him to talk with Dr. Lake. And her name is Julia. So did you make a note? Her name is Julia Lake.
I did make a note so I can. Yeah, I'm going to go to his office this afternoon and go sign it today.
Okay, and so Mr. Chappell, do you have a phone number or address for Julia Lake? Is she what kind of doctor is she? Is she a psychologist? Is she a social worker?
I believe she is a master's in social work.
LPCC. I'm not sure.
Yeah.
MALPCC.
Right.
So she's not really a doctor. She's not a.
The Dr. Sislo's a psychiatrist.
Mama tried.
Okay.
It's not Dr. Cisco, people.
And I do have an address.
Okay, write this down, Mr. Enoch. Address for Dr. Lake.
3454 Oak Alley Court, Suite 504, Toledo, Ohio 43606.
Do you have a phone number?
I do. It is
Okay.
419-318-5833.
Okay.
Did you capture that, Mr. Enix?
I did, yes, sir. And I will share
Okay.
that with Dr. Sislo. Absolutely.
So, and I'm sure Dr. Sislo will want you to sign an authorization, authorize him to speak with Dr. Lake. And Ms. Simon, you'll likewise need to sign an authorization with Dr. Lake, authorizing her to communicate with Dr. Sislo.
Yep,
So it
no
should
problem.
be the professionals that will communicate, not the parties.
Absolutely.
So that's added to this recommendation. Mr. Enix, you agree with this recommendation? Is that correct? That all communication shall be by app close? And that you shall share an app close calendar for all medical appointments, activities for the minor child. And further that the child can be enrolled in online remote school if unable to attend the school medically. Correct?
Yes. I just want to be known again. I haven't had my son in my possession for parenting time since January 6th. And it is now April the 5th. And I've yet to have any extent of parenting time with my child. Other than that, I want my child in school just like everybody else and getting a furthered education.
Okay.
App close. I'm not sure what app close is. If somebody could explain what
It's an app that you can load on your phone.
Okay, like I use Our Family Wizard with my other sons. Is it like
Thank you,
that?
Mama Tried. Look what I was typing
Yes,
up
I
for
think
you.
so. Mr. Chaplin could probably answer the question. There's an
I was
app that he
typing
loads on
that,
his
"Hey,
phone,
Mama, I haven't
correct?
seen
It
you."
is. Yeah.
Thank you for the super
Is it like
dono.
Our Family Wizard? Same kind of
It's
thing?
similar to it. Yes, it has very similar features. Yep.
Okay, perfect, because I like that.
And I-
Yep. But it also has a shared calendar
Mm-hmm.
that is useful as well.
Okay.
And court's understanding there's no cost. The Family Wizard, there's a cost, but there's no cost to App Close. Is that correct, Mr. Chappell?
That's my understanding.
Oh,
Right,
that
thank
code
you
is
for-
free.
Yes. So
Okay, even
load that
better.
app on your phone. Of course, the recommended order also requires they both complete parenting classes. Are they both engaged in parenting classes with their respective therapists? I mean, presumably their therapists provide them some recommendations, guidance, how to co-parent.
Um,
I put Mama Tired because she misses our late shows because the late shows are too late for Mama Tried. So she's Mama Tired.
Chappell?
Your Honor, my client did complete it after the referee's decision. I have the certificate that I can submit to the court, or I can share it.
It's in the court file. It's in the court
Okay.
file.
Yep. So
And that was an online class. Is that correct?
It is, Your Honor. And it was a
All right,
4-hour course study on parent education, support, divorce, et cetera.
Yes, there is such proof in the file. So obviously, if the court adopts this recommendation, Mr. Enix, you need to complete that online class.
Sure, we've done this numerous times over the 11 years. It's been completed before, and I continue to see my therapist every 2 weeks right now. I would ask the court that would be considered
Whole lot of therapy.
as the parenting class. As that's helped me immensely more than any class has, as far as staying on schedule with Dr. Stutzlow and working through issues that way.
How often do you see Dr. Sislow?
Welcome,
We're back to every 2 weeks.
All right. Mr. Chaplin, the court does note that your client completed the class as recommended by the referee. What's your position on Mr. Enix not having to retake that class? He suggests he's already taken it. I don't know
We took one in
offhand.
Florida as well.
Your Honor, I think the class has some good things in it, but I'm not gonna suggest that it will make much of a change here. So I'll leave it to the court's discretion if you want to remove that as a condition.
All right. When did you take the last online parenting class, Mr. Enix? And was it in Florida?
Oh, no, we've done this. We've been at this 11 years here, sir.
When did you last
way back
complete
in the
it?
very beginning. I took one when Hunter was born. See, I've been fighting to be his dad for
Right.
11
That's 11 years ago. When did you
No,
last complete a
11
parenting
years.
class?
11 years ago in Florida, and then another one in Michigan. And then I've been in for 2.5 or over 2 years now with my therapist.
Mr. Enix, when did you last complete a parenting class?
A long time ago, because I go to a
Well,
therapist, which is way better than any parenting class.
All right,
I've learned
all
a
right,
lot from the parent. I can recite things from the parenting class that I went through
All right.
that I think are amazing things. But at the same time, I don't feel it's going to benefit our situation because it's
Right.
more of a counseling issue.
Okay, if you continue with Dr. Soso, that the court be satisfied with that.
Okay,
All
thank
right, so if the court would be inclined to modify the recommendation so that the court would adopt the referee recommended order in part that the defense motion to modify custody be denied, and that the parties not be required to complete parenting class, since Mr. Enix already indicated he's completed the class. The court applauds you, Ms. Simon, for taking the class. Never hurts. But since Mr. Enix is currently involved in every 2 weeks with Dr. Soso, the court will not require him to do so. So with that, I suppose we should, Mr. Walker, I don't know what your suggestion, we simply rescind the recommended order, but add to it that the party shall communicate by APCOS. We'll simply, yes,
Yes, that makes sense, Your Honor.
Looking
Okay.
illegal. What's up, darling?
So,
Put
Mr.
in-
Chaplin, court will,
Put in that motion to change custody is denied.
yeah, so with the,
Coming back.
well, I guess, but that's part of the recommended order, correct? That'd be denied.
Correct.
So perhaps maybe we should leave it the way it is, Mr. Walker. It's cleaner that the court simply adopts and modifies the rec. But you could put in there that the
Parties do not
defendant,
have.
Mr. Enix, is not required to complete another parenting class. Maybe just add a sentence in there. but we will provide that the referee record is adopted. The modified party shall use close app for communication, use a close app calendar. Again, if the minor child is medically unable to attend school in person, the child shall be enrolled online remote school. And further, doctor, if we can add the words doctor defendants, therapist, Dr. Sislo is authorized and permitted to communicate with plaintiff's counselor or therapist, I should say, Dr. Julie. Is it Julie or Julia?
Julie,
Julie, Lake.
yes.
See,
We can add a
Mama
sentence in
tired.
there. Right, Mr. Chappell, with those modifications, clarifications, does your client agree with the revised recommendation?
We are, Your
Love
Honor.
you, Mama tried.
Is Dr. Jara still the primary care physician for the child?
He hasn't been to a primary care physician since the PANDAS diagnosis, and every one of them has discredited her PANDAS diagnosis. I had an appointment on March 17th for him to go there. She could not get him there. I had to cancel. He has to be treated as a new patient. He hasn't seen a primary care physician in over 3 years. He hasn't been to a dentist. He hasn't been to an eye doctor. He hasn't been to anything except for PANDAS doctors. That's the only place she'll take him is a PANDAS doctor. I just would like that on the record while we're here right now.
And
I've been asking for months.
Dr.
sir, for him to
Kowinski
see
is
his
a PANDAS doctor?
He needs a primary care physician in network. And I've been asking for years for that, and especially the last since January, since I haven't seen him. And she's claiming he's having major anxiety, and she won't get him into a psychiatrist. She will only take him to the PANDAS and only treat him that way. That's been my concern, and that's why we're here today, sir.
All right, Dr. Kowinski is the PANDAS doctor, is that correct?
Yes, Your Honor.
Can someone help me out here? What is a PANDAS doctor? Do we know? I don't know this. What is that? Anyone in the chat, help me out. PANDAS. Look it up. Somebody Google it.
Okay, well, the court ordered in July of 2020 that Dr. Jar continue as a primary. Hold on, Mr. Enix, you won't let anyone else talk.
Ooh.
Maybe you should sometimes listen. The court ordered in July of 2020 that Dr. Jar continue as a primary. Hold on, Mr. Enix, you won't let anyone else talk. Maybe you should sometimes listen. The court ordered in July of 2020 that Dr. Jar continue as a primary care physician for the child, so that's never been changed.
It has not been, Your Honor. It has not changed, Your Honor.
So, Mr. Chappell, why is Ms. Simon not taking the child to any other physicians for eye care, dental care, like a dentist?
He had seen the dentist. We had to go. The dentist that was seeing him when he was having an issue, we had to send him up to a specialist up in Ann Arbor because of his PANDAS. Where they were able to do a little bit, but not able to. And then when COVID hit and everything.
Okay, so it seems to me like if just hearing that one, because I haven't heard this one in a while. PANDAS is mental health disorder. Okay, there it is, Peach. All right, so he has a mental health disorder. So she only takes him to the PANDAS doctors. Every other type of health care, dental care, any kind of care, he's not going to. Okay, now we got this straight. Thank you very much. You guys are the best. Look at this. Oh, is this Chat GTP with all this AI? You guys are unbelievable. Thank you, Craig White. Thank you, Peach. Thank you, Lisa. Everybody, thank you. Okay, so we got this clarified. You guys are the best.
Thing kind of shut down.
All right, that was 3 years ago, ma'am.
Yeah, it was.
When did the child last see a dentist?
It was my understanding as well. Mike's mother works at a dental office and was telling me that he was getting care there. That's what I understood. And also, Mr. Enix is also capable of taking him to his pediatrician, to a dentist, to any of these things that he's accusing me of just being.
All right, let's set up a time. Let's set up a time. Okay, to Mr. Enix, and do you agree that Mr. Enix will take the child to the doctor, primary care physician, and that'll be Dr. Jara.
Mm-hmm.
And you make an appointment, and then you make arrangements to have the dad take the child to Dr. Jara and also take him to a dentist. If he's not been to a dentist in a couple of years, he needs to see a dentist at least annually.
He will not leave the house, unfortunately. That's part of the issue right now. His PANDAS is he will not leave the house. I've been trying to get him online therapy. Mr. Enix refuses. I have another pediatrician set up for him that does believe in PANDAS and is familiar with it. But with all of the issues that we've had with Mr. Enix. Even his panda specialist, Mike, sent him a cease and desist order to stop treating Hunter. And because of the abusive behavior, he also won't see Hunter until Mr. Enix is not allowed to be involved in the office. So it's not that I don't want him to go to these things. It's unfortunately Hunter cannot leave the house. It's because of his pandas, they become almost agoraphobic, which is the
And
reason
what if you
he won't
take
go to
him?
school.
Will he allow you to take him, Miss Simon?
He won't even, we were just on spring break last week and I took the week off with him and I was just trying to get him to go to a drive-through with me. So he didn't have to, he would leave the house, but he wouldn't have to leave the car. He won't even leave the house at all. He's just uncomfortable. And it's part of pandas. It's not just a Hunter thing. It's something that this disease causes these children to be afraid to leave their house, afraid to leave their safe place, afraid to separate from a parent.
Okay, but do you think it's gonna be, he can't be that way his entire life, Miss Simon. So what are you doing to address this? And I understand it's disputed on the part of Mr. Enix whether or not this child is properly diagnosed as having pandas. But what are you doing to address this long term? And he can't stay in your house for the rest of his life, correct?
Your Honor, just so that the court has a little more context, there were no issues in this case for about 2.5 years. Hunter was doing quite well. He did have, he got strep in early January, and that's when these problems started. And pandas is related to strep. That's what causes it in that regard. The difficulty that we have right now, and we are filing a motion to address this, is that Mr. Enix refuses to agree to any form of treatment. So we have the current order that the parties have to make joint decisions, and he refuses everything. He even refused, we're hoping that this order allows Hunter to be in online school. Mr. Enix has refused to even do the online schooling. We had a truancy meeting with the prosecutor on March 23rd to go over these issues as well. And Mr. Enix's solution, rather than having him start online, was for the prosecutor to charge all three. So not just the parents, but Hunter as well. So we can't do anything because he won't agree to anything. And we do have a motion coming to the court to change how medical decisions are made so that we can hopefully make some progress.
Bro, would these be excused absences if Miss Simon brought in documentation this child has this condition? Would that be an excused absence from the school? But obviously it's not recognized by someone because of the prosecutor's charging with truancy.
It was the pre-charge meeting with the prosecutor. I don't know what they're going to do at this point, but Mr. Skaggs indicated that he was going to reach out to the school about the online option and find out if, in fact, Mr. Enix did not agree to it. But I want the court to understand that Mr. Enix's response is, please charge us all with a crime rather than moving it forward in that regard.
Okay. Well, the order the court's going to enter today does require that the child be enrolled in online remote school if medically unable to attend. And he's not attended in person since January. Is that correct?
January 6th was his last day of school, sir.
All right.
And the reason
Thanks, right. Mr. Enix, hold on just a minute. That's a long term. Mr. Chappell, Mr. Enix, Ms. Simon, do we need to get Hunter evaluated by a third party, taking him to U of M or some facility that specialists can document and verify?
He's
if in
already been
fact,
to U of M and they
Mr.
denied
Enix,
pandas.
if in fact you dispute the findings of Dr. Korinsky, maybe we need to have an independent physician evaluate Hunter.
Has
that ever been done?
Sir, he's actually been to the University of Michigan. They went through the whole thing and they concluded that he did not have pandas. That was actually the first place that she took him back then. And because she didn't get the answer, she went doctor chasing, ended up at Sancta Familia. Once I got involved with them and started asking questions, it went to Cleveland. Once I got involved there, and then all pediatricians were stopped. I've been asking for normal in-network care and psychiatric care for my child, and I get all refusal.
Okay,
period.
so you have letters, documentation that this from other physicians, that Hunter does not have this condition.
In our file,
Is that
sir,
correct?
that's on your desk.
Now, I know it's a train wreck and Dad is a little super aggressive, but if you two sides to every story here, Mom, I'm seeing you guys putting Munchausen syndrome by proxy. Pandis, yes. As I'm looking at this, I'm reading it right now, and I saw what you guys put in the chat. It seems a very real disease. Not leaving the house, all that other stuff. Could be Mom. And I think Dad is quite frustrated because he is trying to get a whole health approach for his son. And the fact also is truancy. If the school thinks that there's really something wrong in terms of pandas, a school is going to recognize the absences. They are not going to call truancy if he has a certified health disorder. So for the truancy, this seems like Mom is a little, and Dad just may be frustrated. It's two sides to every story. I think both of them are a little off the deep end, but I think Dad is frustrated because of what's going on.
There, we have got over 7 doctors from the last time we were here, from a neurologist to a pediatrician to a psychological doctor to an immunologist, that all said that the treatment Hunter was on at that time should have been stopped. Once I went back to Dr. K's office and you guys granted me the half and half time sharing, everything stopped. And as soon as everything stopped, Hunter flourished. He took off like a rocket as far as everything. And then this year, when we started school, I know Panda's thing started in January, she's saying, but my problem is he's missed a total of 72 days this year. She's had 1 week where she's had him in school for the whole week. And that was November 13th through the 20th. That's the only week in her care that she's had him to school where there hasn't been some kind of sickness.
All right, Mr. Enix, all the documents and reports that you reference may be in possession of the front of the court. I'm not so sure they're in the court file.
They are definitely in the court file. I got copies from
Mr. Chappell, when Miss Simon takes him Hunter to school, does he refuse to get out of the vehicle?
Your Honor, he refuses to get out of the house at the current time period. The last time he went to school, by the way, was January 20th. It wasn't January 6th.
Okay.
And it was.
So he just absolutely refuses.
And
she's
that's
got
why
to.
He went to school till noon that day. You're right.
Right. At some point in time, he's got to leave that house. There's got to be some long-term solutions to this.
Even judges.
I mean, obviously, a lot of times parents say, well, my child didn't want to go to school. Well, the child has to go to school. That's the reality. So my baby mom needs to provide some discipline and some limits to convince him that he has to go to school.
Well, and Judge, we may have to then have I'll suggest that, the pandas is it's a diagnosis that I don't believe a lot of people understand. We may end up having to have a hearing so that the court, can hear from the professionals. These are doctors, they're not, they are medical doctors that provide the diagnosis so that the court can hear from them directly as well, so that we can have some positive direction. The thing I'll note is that, again, we had 2.5 years where things were great. And then we have a strep outbreak where he gets strep.
Not until January.
We're right back to where we were 2.5 years ago, Judge.
Well, that strep happened in January, so it's now April. Has the strep subsided, so he can maybe go back to school?
Well, and again, Your Honor, it deals with the swelling that occurs in the brain as a result of the strep. It's actually a form of encephalitis. I'm not the doctor here, but I've read enough so I can talk about what it does, etc. It isn't as simple as saying the strep infection is gone. What happens is when this hits, it creates a sudden and severe outbreak of OCD disorders. And that's what Hunter has been in the grips of. Now, there are separate issues that he has with his dad that, we shared with Mr. Walker as well, relative to how Mr. Enix treats him and handles him. Mr. Enix has recently told him that, he's going to give up on him. I mean, there's other issues that he has with Mr. Enix.
Completely out of context.
Is there any medication, Mr. Chappell, that Hunter can be administered to address the situation, to reduce the swelling of the brain, or
Antibiotics, Your Honor.
Start going back.
May I address something? Sir,
Antibiotics.
Hold on, Mr. Enix. Hold on, Mr.
okay,
Enix.
there's a huge
Relax.
point to
Relax,
what he's
Mr.
trying to
Enix.
make right now.
Okay. Is there any medication that Hunter can be provided?
Antibiotics, Your Honor, yes.
Is he receiving antibiotics right now?
We can't get them in because we do not have, Mr. Enix has sent cease and desist orders to every
Okay.
doctor.
Hold on.
Okay.
Can I make a statement here?
Okay, just Mr. Enix, let me ask a question. Do you
I'm a
have
very
an objection
concerned parent
to,
with what
do
he
you have an
just said,
objection
Your
to
Honor.
Ms. Simon filling a prescription?
Absolutely. And
right.
here's why.
Okay,
Sir,
Mr. Enix, hold on, Mr. Enix. Mr. Chappell, Mr. Enix says there's a number of physicians that have independently examined Hunter and disagree with the diagnosis. Do you have a copy of those reports?
I don't think they all say that, Your Honor, but we have them from the past file, yes.
All right, so that's what I guess we should do is both parties should get together, subpoena the physicians, and let's have a hearing or take depositions to determine so this court can decide whether or not this is an accurate, true diagnosis or not. But
very concerned
Mom
with
and Dad,
knowledge that
you
was
need to
just
get
brought
Hunter
up.
out of that home. He can't live in that home forever. So whatever the two of you need to do to work together, we both need to be on the same page with the doctor and address it. You can't imagine this child living the rest of his life without leaving the house.
So, Denny.
he just made a very big claim, Your Honor, that Hunter's behavior is due to a swollen brain putting pressure on certain areas. With that said, and I understand that you read that, and that's fine, but I've asked Ms. Simon because I actually know 3 children with pandas, one of which was in the network of Bedford schools for a while, but they all say that their children not only have a doctor, but they have a psychiatric doctor that this doctor would see, and they get CT scans and MRIs. Now, I've asked Ms. Simon when she got an MRI to say our son's brain was swollen, putting this pressure, causing this.
So that one cut. What happened was they went back to the ruling, and basically I'm waiting for the second. They did not get a ruling on it. Judge Mark did not give a ruling. That is as much as I could get on that. Unfortunately, we live and die by the record button. But that was good. There is a part 2. So everything I did for the Saturday special is a part 2. So we're going to look for that. I think it's actually this week coming up. That's why I premiered it today on Saturday. So what had happened was Mr. Enix, they just adjourned it, and we are waiting for the names to appear on the docket. I have it written down in my notebook of fun. Here we go. Main event time, people. Are we ready? Here we go.
All right.
Okay, so with this one, guys, so he was here to plea. Hear his plea. He's been back and forth to court. She gives him a chance to talk. It kind of goes a little off the rails. And I am not going to spoil anything else. Here we go. Bang.
We report it back just to give Mr. Jackson an opportunity to think through how he wished to proceed, and what is your position?
Can I say what I need to say? What I was asking you earlier.
As I kind of advised you earlier, or at least warned you earlier, that you got to be careful about what you say if it's related to something that's going to be presented at trial. So just be mindful of that. Okay.
Understood.
Okay.
Now, the first thing I want to say is that I feel like I'm forced to take a plea that I'm not agreeing with. I feel like I'm forced to take a plea without fully agreeing to it. Secondly, that you are not giving me enough time to call my people and let them know and see what their thoughts were. I already don't agree, and I already told you And I didn't tell the court that he came yesterday and he said that he felt like I'm guilty, take the plea. And then as I decide to leave out the attorney room, he's going to say, oh, what's your sizes for trial? So he already feel like I'm guilty. I don't even believe that he's working on my behalf. And again, today, for like 5 hours is not enough to make a decision on your life. You all are free. You all work, do, handle your business. You all free. 5 hours is not enough when someone is saying, oh, you have to face 30 years. 5 hours is not enough to make have a official decision. So I feel that I'm being forced by everybody at this point. At first, it seems like just the DA and him, but now it seems like I'm being forced by everybody because if you don't take the plea today, you will go to trial Monday. That's all I have to say.
I understand, and but that is your reality. Your reality is that you have been charged with murder, and you have been. I know at this juncture, you had to be waiting for over a year. How long have you been in jail?
I've been in custody since 2019, but
2019.
I've been in Fulton County.
How long have you been in DeKalb? How long? Let me pull
3
up
years now.
How long?
3 years now.
And at no time during the 3 years, you didn't think this moment was coming?
No, I asked him to have, speak to the DA to get the charge reduced to 30 do 15, 30 do 25.
Well, you do recognize everybody can't get that for you, right? Like, everybody comes in with charges. They don't always get them reduced. That doesn't always happen. So whether someone is working for you or not working for you is not indicative of whether or not they can get a plea reduced. Or, a charge reduced.
I wasn't asking the charge to be reduced. I've heard by deputies and people at the facility saying that you could have a 30 do 25, a 30 do 15, or 30 do 17. That's not necessarily reducing the charges. You just 30 do that time in the correctional facility.
I'm sorry, that is not true. Malice murder, there is no 17 to do 30 to do 17 on a malice murder. Malice murder is a life sentence or life without the possibility of parole. There is nothing else. Now, you can get your case reduced from a malice murder to, say, a voluntary murder, or and then you might be looking at a reduction in time. But as a malice murder, there is nothing else. So here you are.
Can I come back Monday and think this through and call my people to have a final decision?
No. And I would also assume that you were on the last calendars, and I always make this clear on all my calendars, so it is not new. When I get ready to start a trial, the week of, I do not take pleas, they're blind. I say that on every calendar that in the last 5 years or so, probably more, I always make that statement on all of our pre-trials. This is not new. And so you have to make a decision as to what you're doing. And it may feel like it's forced. It's not forced. It's just a reality. The reality is that we're going to trial on Monday. It is a trial week. You're up. So you need to let me know whether or not you're going to take a plea, which is up to you. Because if you feel you're not forced, you don't want to take the plea, you go to trial. That is up to you. Okay. So what are you doing?
I don't know. I've said this numerous of times. You're not even allowing me to wait till Monday and come back on Monday and have a final decision. I don't know. I already don't agree with both. One is this, one is that. I don't agree with both. No one is not being reasonable or trying to be understanding, so I don't know. I do not absolutely know.
Right. So here's how it works. If you don't know, you go to trial, okay? Because I'm not going to force you to take a plea. But if you don't take a plea, you're going to trial, okay? And if your position is you don't know, then on Monday, you'll come back And even if you do know, that plea will be blind. Okay. And at that point, the court hears what the state is going to hear. I hear what Mr. Queen says, and I sentence you. Okay. I don't know about your case right now. If I know something about your case, I don't know it because no one's brought it to my attention. So I don't know the facts and backgrounds of your case. As I sit right here, I don't know them. So because I don't recall having any motions. Maybe we did,
Theron.
and my mind will be refreshed. But for right now, I don't know. But at some point, they're going to tell that, and I'm going to make a decision. And there you go. But
So
one of the benefits of pleading is that you get the idea that jurors are not brought up. The state doesn't spend the whole weekend preparing for something, and then you come in and decide to do something else. So it's a consideration of all of those things as to taking a plea and taking getting the lesser sentence, because it's basically an appreciation of you accepting responsibility, the financial or the economics that's involved in bringing jurors when that won't be necessary because you've accepted responsibility. All of those things play into part why pleas are generally lesser time than if you were to go to trial sometimes, because facts and circumstances come out, and that generally makes a big difference. Okay, so I don't have all day, and I don't mean to rush you, but like I told you, it is what it is. I need to know what you're going to do.
One more question. If you don't know the facts of the case, why would I plead to something if you don't know the facts of the case? That's just pleading something you just agree with the state and not even know what's going on.
If you decide to take a plea, they'll tell me. That's the whole process.
Are you still going to agree with them? That's what I want to know.
Well, if it's a malice murder, I really don't have a choice, because I can't control a malice murder. I can't reduce it. Okay, so I don't have the authority to reduce a malice murder case. Even if I agree with you, like I'm like, ooh, that's a good voluntary manslaughter, or that's a good involuntary manslaughter, I still could not reduce it because I don't have the authority to do that without the state's involvement. Now, there you have that. That's on the record. I can't do it without the state.
I see you guys in the chat. This is a malice murder charge. They're going to explain what happened. So this was the day that he was supposed to take his plea, and he's backing out.
State.
Just go forward with the plea.
All right.
Your Honor, may I remain seated?
Yep.
Your Honor, this is the state of Georgia versus Devin Jamal Jackson, case number 20 CR 2718. He's charged in this indictment with count 1 malice murder, count 2 felony murder, count 3 felony murder, counts 4, 5, and 6 are aggravated assault, count 7 is armed robbery, count 8 is possession of a knife during the commission of a felony. The incident date was May 8th, 2019. On that date, family members of the victim, Keontae Metz, called or went to his apartment complex after not having heard from him for about 12 hours. When they got there, they saw blood on his blinds. They went to the leasing office, called the police as well, and the police went to the apartment, Mr. Metz's apartment. As soon as they opened the door, there was blood everywhere.
Thank you.
There was blood on the walls. There were bloody footprints all the way through the living room. They cleared the house, ultimately locating the victim, Mr. Metz, deceased. He was in his bedroom. He was in his underwear, covered in blood. They cordoned off the scene and began speaking with witnesses. One of them they spoke to is Gregory Gardner. He stated that he had been with the victim the day before and that there was a young man there with him. That person was the defendant. Mr. Gregory Gardner said that he left around 9 o'clock that night and he didn't hear from the victim anymore. Officers spoke with the leasing office, and they had surveillance from the day before, which showed Keontae Metz and the defendant walking through the apartment complex together. They had just returned from a phone store. They were walking through, it was about 4 o'clock in the afternoon. And once they got that still shot from the apartment complex, they put a bolo out. Officers got a number of calls. People recognized the defendant. They said his name was Devon Jackson. In fact, he had been at the apartment complex about 2 weeks prior, inquiring about a unit there. He was put on a wait list. He gave his name, his number, and all that. Mr. Jackson was subsequently arrested 2 days later. And so what we determined was that the defendant had been staying with the victim, Mr. Metz, for about somewhere between 2 and 3 weeks. They met on a website or an app called Jacked, and the victim was living here in an apartment complex, Trinity Walk Apartments. The victim was autistic. He was developmentally delayed and legally blind, but he was able to function for himself. He could live by himself, pay bills, but he did have some challenges. So the defendant began living with him sometime mid-April. And on this particular day, they went out, they got a phone, they came back to the apartment. Around 2 a.m., Mr. Metz calls a family friend and tells them that the defendant has his cell phone. And he has a house phone, so I assume he's using his house phone. But he calls the family friend around 2 a.m., and I believe there's a conversation about putting the defendant out. And so this family friend tells him, well, it's 2 o'clock in the morning, don't put him out. It's the middle of the night, wait until the morning. And something just goes terribly wrong. Around 5 a.m., you can see there's surveillance from the apartment complex where the defendant is traveling to the dumpster. He travels to the dumpster with trash bags 2 times, trash bags in both hands, and he throws items away from the house. I assume it's whatever he used to beat Mr. Metz, sheets, because there's no sheets on the bed, towels, probably his clothes. And you see him walking around 5 a.m. to the dumpster. At 7:45, the trash folks come and they take the dumpster. So we were not able to recover those items that he threw away. About 8:15, the defendant makes one last trip to the dumpster where I think he throws one more bag. He's standing there. At this point, he has a glove on his hand because I believe he's been cut. He then goes to this Decatur MARTA station. He's seen on MARTA coming in. He again has that same glove on his hand, and he takes off. He is arrested 2 days later in Atlanta at an address off of Martin Luther King Drive. In his possession is the victim's cell phone. They bring him in to be interviewed. His interview was about 2 hours. He lies throughout the entire interview until they literally have to confront him with pictures of himself at the dumpster. He explains away or attempts to explain away a lot of it. He says there was another person involved. There was another person in the house that stabbed Mr. Metz. Ultimately, he says that they got into a physical altercation and that he had to stab Mr. Metz twice out of self-defense. Mr. Metz was brutally murdered. He was stabbed 12 times in his back. He was strangled. His hyoid bone was fractured. He had bruises all over his body. His skull was fractured. His orbital socket was fractured. His teeth were knocked out. I don't know what he beat him with. There's chunks of wood in the house that I believe came from maybe a table leg, but I don't know because I believe he threw it away. But he beat him to death. The cause of death is blunt force trauma to the head. I mean, his scalp is just completely ruined. He has cuts to the back of his head. So the cause of death was blunt force trauma to the head. Other complications or other significant injuries being strangulation, manual strangulation, as well as 12 stab wounds to his back. The defendant said that when he left, the victim was alive. That it just isn't the case. The house was a mess. It was completely bloody. At the crime scene, the defendant said he tried to clean up. There's bottles of bleach, pine saw bottle, 2 first aid kits where he says he tried to help the victim. They asked him why he was cleaning up. I don't think he really gives a good reason. I mean, there was no way he was going to clean it up because there's just blood on the walls, on the doors, on the light switch, in the carpet, on the blinds in the back room where, I mean, you can tell the victim is running around the house trying to get away from him. And so that, I think that covers the facts. He was arrested by Atlanta police at that Atlanta address. He had an open case out of Fulton County. And so Fulton County held him until 2020. And that's when he was brought over to DeKalb. So he was arrested May 10th, 2019. He was brought to DeKalb March 6th, 2020. As far as his criminal history, he has a open burglary case here in DeKalb County. It's been indicted as 23 CR 1730. He has a June 2018 criminal trespass out of Fulton County, a June 2019 simple assault, ag assault reduced to simple assault out of Fulton County.
Mr. Russell.
While he's been in custody, he has incurred 2 new charges, one from January 2021, interference with government property. It's alleged that he damaged a television while at the jail. That's D0283586. He has an October 2021 terroristic threats, also at the jail, D0287203. What the state is recommending on count 1 malice murder, that the court would sentence Mr. Jackson to life in prison. Counts 2 and 3, the felony murders, would vacate as a matter of law. Count 4 would merge into count 1. Count 5 would be null pros. Count 6 would be null pros.
I'm sorry,
Likewise.
hold on for a second.
Okay.
I'm gonna do them all next to that. Okay, malice murder, life, felony murder.
I know. But I'm still going through my recommendation. But she has to write something on the sentence sheet.
Little infighting too. You see the lawyers going at it.
Can I just put my recommendation on there? What they're gonna vacate.
Told you this was a goodie.
They're gonna vacate. I'm not. These two are gonna vacate. That'll merge and I'm not crossing all these. What's the thing? That's not the conversation. I'm still gonna put that. I'm not crossing counts 5 through 6. Why'd you put 4 through 6 here? That's not the
I'm a fan of
understanding.
this judge. She's very well spoken. I've seen her before, but this one really caught my attention.
Okay. All right. So negotiated, unnegotiated?
It's
where are we?
negotiated, Judge, and I think I feel like it's semantics. I think Mr. Queen was under the impression that he would just plead to count 1 and I would dismiss everything else. Essentially, that's what's happening. He can't be sentenced on 2, he can't be sentenced on 3, he can't be sentenced on 4 because they'll vacate and 1 will merge. The plan is to null pros counts 5 through 8. So I don't understand what.
You're no processing what, the aggravated assault?
Yes, Your Honor, the aggravated assault count 5, aggravated assault count 6, armed robbery count 7, possession of a knife during the commission of a felony count 8.
So are you keeping 4?
Yeah, 4
So
would
for
merge.
So the merge, vacate, that's what you were thinking?
That's what I was
Okay.
thinking, Judge.
Okay, and Mr. Queen, your thought was, and I think I even mentioned it to Mr. Jackson when we were having that conversation, ex parte conversation at the bench, that was what the state was going to do, but the state's position is different. I don't know what that means for you.
I think because Ms. Lippert came and my understanding was the plea would be only to count 1, because I think the misunderstanding is if he pleads to count 1, in order for 2 and 3 to vacate, he would have to plead guilty to them. Because they don't vacate if he doesn't plead to them.
That's fine, Judge. I will dismiss counts 2 through 8. The state's offer is life on count 1.
Okay.
And I do believe that the next of kin wrote a letter, and if Ms. Young could read that at the court's preference.
Okay. Is the next of kin here, is that Ms. Cotton?
I don't believe so, Judge.
That's the cousin of the next of the deceased victim. But I'll be reading the statement, Judge Perry.
Okay, so so before we get there, so we have we're gonna do just malice murder count 1 and dismissing 2 through 8. Behind felony murder, you have 4 through 6. What is that? Oh, those are the underlining accounts that relates to, okay. I see
Yes,
what you're
one
saying.
is blunt force trauma, one is strangulation, one is a knife.
Okay. Yeah. Yeah, these right here are gonna end up 4 through 6.
It's not on the indictment, it's just an opposite.
Yeah, you don't have to. I
So
think,
take it out.
yeah, those are just so we'll know what the underlining numbers were related to it. That's why she put those there. All right, okay, so on life malice murder and the date of time for credit time would be, I think you said starting in March?
May 10th, well, he was
May
brought to DeKalb on March 6th,
March 6th.
2020.
Okay, so, all right then, Mr. Quinn.
I think he served with warrant in Atlanta though. So actually it is the May date, because he was served with warrant in Atlanta. Yeah.
So he just
They just found him there. But he got hit with 2 warrants, so.
You're gonna know pros 2 through 8, right?
Yes, Your Honor.
Okay. All right. Anything else, anything further other than the statement from the witness? I mean, from your next of kin?
No, Your Honor.
All right. And I'm gonna listen to the advocate statement and then I'll let you proceed. All right, you may proceed.
Good afternoon, Your Honor. To the courts, this is on behalf of the Keontae Metz family. To the courts, today is the day that we finally receive justice, but also the day we relive the horror from May 8th, 2019. To this day, to fathom that someone who was a brother, uncle, cousin, friend, to be harmed in such a senseless and gruesome way is still unimaginable. Keontae will always be remembered as a person who was full of life, courageous, brave, loving, outgoing, and overall selfless, and the most caring person one could encounter in this lifetime. He fought hard all his life just to live. Keontae was born premature with a twin brother who did not live, declared legally blind, diagnosed with autism, and still managed to brighten everyone's day and maintain a good life for himself. Keontae finished high school, got his own apartment, and overcame all odds against him since birth. Keontae impacted the lives of everyone who knew him in amazing ways. His family and friends will never hear his contagious laugh, see him smile, hang out with him, talk to him, or just the simple things that meant to the world to us all. And that's the statement on behalf of Keontae Metz family.
Ms. Quinn.
So, Your Honor, we have before you Mr. Jackson, and you heard about the allegations in the case. In this case, it is sad, it's tragic all the way around. We've had Mr. Jackson evaluated on 2 occasions. Because Mr. Jackson, I think he's evidence that broken people break people. Mr. Jackson, Your Honor, he's currently 24 years old, single, didn't have any kids. He did go to the Miller's Academy over in Lithonia, and he got a certificate there. He did work some jobs. Most recently, prior to his arrest, he was doing security work. As you've heard, Mr. Jackson, he's had a few skirts with the law. He has no convictions. But Mr. Jackson, at the age of 8, he was in a home which was plagued by violence. At the age of 8, Mr. Jackson was emotionally, physically, and then subsequently sexually abused. Mr. Jackson, beginning at the age of 8, was placed inside defects custody. He's been in and out of the foster care system. He's been treated multiple times at Georgia Regional. He does have a diagnosis of bipolar disorder. Mr. Jackson, he's had a very hard life. And so we believe that we provide the state with both evaluations, and they're consistent to Mr. Jackson. He is between low to extremely low functioning. He suffered neglect. He suffered abuse. He suffered direct and secondary trauma and distress from a very, very, very young age. He's been in the system, out the system, in hospital, out of hospital. And he and Mr. Metz, they were friends. They were friends. And why this happened, I know the state's theory, it was something over a cell phone. Is it that simple? I really couldn't tell the court. But Mr. Jackson, he has his own set of difficulties and challenges which he's worked to overcome, but eventually he was unable. I know my social worker and I, we've met Mr. Jackson on some occasions to go through the evidence, and the evidence is quite damaging. And Mr. Jackson, I know, like I said, we had him evaluated twice, and the hope was that through the mitigation we presented to the state, that the state would be willing to reduce the charge, but the state's been unwilling to do that. And we are where we are today. Because generally the state's been consistent that offer has always been life. And that's where we are today. So unfortunately, it's a decision Mr. Jackson did not wish to make, but obviously he must make, given the allegations, given that he is facing a more severe sentence if he were to go to trial and lose. So Judge, I believe this may be in Mr. Jackson's best interest, though it's not what he desires from the court. And I believe he wishes to go forward with a plea this time. So we ask the court to accept the plea.
Okay. I indicated that the court would listen and determine whether or not the court accepts the no pros. I can tell you, in light of the information that Jess presented to the court, this is one of the ones I probably would not have accepted. That's based on what she just indicated. That's horrible. Someone fought for the allegedly, well, I guess it's not allegedly, fought for their lives from one room to another. Blood everywhere, as she's just presented. I'm assuming a young man as well who has a disability. Life was taken from him and nobody knows why. Just has a sense of senselessness. I don't recall particularly hearing this case before, but
Judge, you heard a bond hearing from my
I did.
records. You heard a bond hearing way back in 20, 19.
Did I? Okay.
So you've heard many cases in between. You heard the bond hearing back, it was like August 2019.
Yeah, but those facts seem like they should have stayed with me. What happened to the, are there any hearings related to the statement that he gave? And is that still part of the evidence, the statement there wherein he admitted to stabbing him?
That would be part of the evidence. We did not have a hearing on it. That was one of the pending matters.
Okay. In the statement, he actually indicates he stabs him, or is it innuendo he stabs him?
His statement is, it alludes to it being a matter of self-defense.
Self-defense.
That the decedent came at him with a knife. They struggled over the knife, and then ultimately he got the knife and struck the decedent.
And is he blind? Is he blind as in what kind
Legally
of?
blind, but not like totally blind.
Okay.
Blind such that you couldn't pass a driver's test, but blind, but not blind, you couldn't get around.
Okay.
His statement is that he only stabbed him twice, and that when he left that morning, the victim was alive. That's not the case. The evidence does not suggest that at all. It wasn't just twice. But he's very clear. He says twice, like it's not inferred. He says that.
So Judge, he admits to the allegation.
What's up,
and
Welsh?
Ultimately, he was extremely remorseful about the allegation.
He didn't seem remorseful when the state was reading the recitation of facts. It didn't look remorseful to the court.
Judge, I've spoken with Mr. Jackson multiple times. He is extremely remorseful. He's always wanted to resolve this matter. But, you know, as anyone naturally would, he would be hopeful that it'd be a better resolution than a potential life sentence in prison. So that's where we are, Judge.
Yeah, I don't think you can get a resolution, at least from the court, because I barely want this one. Mr. Jackson, you about to get what you wanted, because I don't think I'm taking this. Let me think. Sit in the back, give me a second. Let me do Mr. Middleton case, Kimbrough. Give me a moment.
What's up, Welsh? How we doing, WNN? Guys, make sure to check out the Welsh News Network. I think they stream longer than me.
Yes.
Which is hard. They're the best. Dan and Becca. I did, Richard, I asked should. Should was the first poll, Rich. Now we're saying will she do it. First one was should, Richard. Now we're doing will. And she... Does she or doesn't she? So, I edited this video. Guys, I truly thank you all. I'm so glad I came on Saturday stream. I think I may be making this a staple for members. Everybody's green. So, blue, green. So I'm gonna, and this is edited, so it's gonna hop right to the end.
All right, I've asked to see the photographs. I want to kind of see what the circumstances were.
Yes, Judge. Do you just want to thumb through the photos?
Y'all just thumb through them.
Okay, you'll have them outside.
Mm-hmm.
put those votes in, people. Let's throw up some judge emojis. Let's do it. I am going out with the missus to Hoboken tonight. Hoboken, New Jersey. It is right over the bridge and tunnel to the city. It is beautiful out there tonight. It's actually muggy, guys. Jersey. Yeah. And the judge is disgusted by these pictures. Could you imagine what those pictures must look like, guys? Oh my god. Yes, Diver Dan, I know. Told you this was gonna be a goodie. And I warmed it up with that last one too. I can't wait to see part 2 of this. This one is supposedly gonna have a part 2 also. So if you could read between the lines. Farron, I was born here. I had no choice. Yes. Judge Bari, guys, she's awesome. She's like this every day. The suspense is killing us. I'm purposely doing this to you. Torturing you guys.
All right.
Judge, before you any motion Tuesday morning after the select.
That'll be fine.
Because she's not willing to accept.
All right, thank you.
So. Come on, Jack. So thank you. What was that one? I guess the question. Both sides.
And Judge, may I be excused?
You may.
Thank you.
Mhm.
Oh,
So,
Brown. Give that back to the clerk.
so the judge is not taking the plea, and it's judge reporting. So we are going to hear. I hope she puts it on her stream. She's going to sentence him on her own. Oh boy, guys! Kitchen Court Cases is going live at 6 p.m. I think she's going to be doing some crazy TPOs that she got stored in the vault. Guys, I am looking forward to another awesome week of lives with you guys. And also, Thursday, remember, I'll be throwing promos out. We have Mikey the Legend from Credence and Mikey Show coming to you on Time Served Live. We're going to be having a good time Thursday. Guys, enjoy your Saturday. Kiss your loved ones. Make sure that you remember that you have been